Today's webinar, GDPR and Privacy Best Practices for Digital Marketers, will be presented by Ryan Horner and Bob Beach. As a Managing Director of Technology, Ryan is responsible for overseeing OneNorth's strategy related to technical applications, systems, client implementations. Ryan has more than 15 years of experience architecting, designing, and managing technology teams. He and the rest of the technology team offer unique solutions and open up new possibilities for marketing and business development professionals. Bob Beach is an expert in technology strategy, design, and implementation. In his 15-plus years in the legal technology space, he has worked for several industry leaders, designing and building software solutions, and providing consulting services to dozens of AM law firms, as well as several firms in the UK. With that, I'll turn it over to our speakers.
Thanks, Olivia. Hello, welcome to the webinar, everyone. This is Ryan Horner. I think I'll start by talking about how important it is at OneNorth that we partner with our clients to adapt and evolve to changes in the industry and in digital marketing. And there are changes we need to make in how we handle broadly data privacy, and more specifically GDPR as an implementation of data privacy. So in that effort, our agenda today is to start with an overview of what GDPR is out of the EU, talk a little bit about the broader landscape of data privacy expectations of the users visiting our site. And then we've identified and distilled down 5 key concepts that you can take out of the GDPR as a digital marketer. And then we'll do an applied example to modern marketing automation to understand it more clearly, and then talk through a process and steps that you can take now to start addressing data privacy more fully. GDPR is the General Data Protection Regulation out of the European Union. It was started in 2012 to be an idea that they wanted to create something that would standardize data privacy laws where many countries had their own regulations, which made it really infeasible to deliver across a global web. And it became much more than that, though. It became a goal to protect and empower all EU citizens from data privacy and breaches thereof. And the first recital, which is the start of the regulation, it makes it really clear that the protection of natural persons in relation to the processing of personal data is a fundamental right. So this is a bold statement with no small goal to ultimately reshape the way organizations approach data privacy. So that's the first thing to think and know about GDPR, is that they're changing the notion of enterprises owning the data they have about their users to the users owning that data. And that is a fundamental conceptual change to account for. It is a 261-page regulation, not that large by regulation standards, and fairly readable, actually. There are 173 recitals and 99 articles. We reference that because we will refer back to them as we go through the presentation. Timeline on regulation. It was ratified by the EU Parliament in 2016, and enforcement will begin in May 25th. So it's currently law and regulation right now. We're just in a grace period. So that's only 63 calendar days away from now. So I would call that imminent timeline. Who and where? So what people, what persons and data needs to be protected, and which organizations need to. The regulation states that the GDPR will apply to organizations located outside of the EU under the condition that there are goods or services they offer, or that they're monitoring the behavior of EU data subjects. Furthermore, it indicates that this will apply to all companies if you process and hold data of data subjects residing in the European Union. That would mean you don't even have to be a citizen, just that you're physically in the geography of the European Union. And that's regardless of your enterprise's location. And the way that they're able to get international law to apply there, as stated in the regulation, is that they can apply that through diplomatic or consular post means so that they can enforce the regulation in that way. So it's broad coverage with a broad goal. So why do we care? Regulations always have some notion of fines, and the fines here would be defined as punitive. 4% of annual revenue. That's not margin or profit, but that's revenue of an organization. So for a large enterprise, we're talking very sizable sums. And that's done on purpose to guarantee attention and adherence and respect for the regulation, which is the goal. But it's not just the fines, which is why we should care about that. GDPR is one example. I think the news flow this week is indicating that there's a higher chance that more regulation will be coming in other areas. So if that's going to happen, the sooner you can address that, the better. And also just the nature of data breaches and loss of personal information has such a negative connotation to a given firm's brand, to a PR, to news cycles, that it's worth taking action to avoid that on its own. And then finally, we'll talk about this a little more, but the user expectations for the data that they're sharing is changing in ways that if we want to achieve our marketing goals, we need to meet them where they're coming from. The how is like many other change journeys in enterprises. It starts with awareness, which this webinar is meant to be beginning education of. And it's about a process to sort of initiate change within the organization. And we'll talk about that at the end of the webinar, about a simple process to do that. But I think importantly, like many complex problems in enterprises today, it requires a cross-disciplinary team, certainly marketing, PR, IT, all the different groups within the department, but also legal counsel. So because it is a legal regulation, each organization is unique, and you'll need your own legal counsel to interpret the specifics of your situation. So the GDPR was not defined in a vacuum. It's defined in a culture where people have experiences around how their data privacy is being handled and the trust thereof. And I thought I was going to have to spend a lot more time on this section before the news flow of this week, where we got a breach of Facebook to a company called Cambridge Analytica of users' personal data that shared up to 50 million Facebook user accounts with no consent from them. So this has been over half of the news cycles over the last couple of days, certainly partly because there's a political angle here, but you have governors, senators, UK Parliament, all demanding CEO Zuckerberg of Facebook to come before them and come to account of how they have lost trust of the user's data. So, you know, it creates a perspective of your users that other large corporations they've entrusted their data to was not cared for well. And that's not just one anecdotal example. We've got Yahoo with such a sizable 500 million accounts stolen, and that's on top of Equifax, which lost 143 million accounts. And this one was interesting because the data was not given to Equifax by individuals. It was the product of Equifax that they did not care for. They were not good stewards of that data, and it creates the psychology of our users that trust of enterprises with their data has been harmed. And that's just a few anecdotal examples. So I think there's a narrative story here, and we have some stats from some great studies about the state of data privacy in the US. It starts with Accenture's Tech Vision, where they were asking people about how important trust was to the digital economy. And not terribly surprisingly, 8 out of 10 said that it was very important. And then Pew Research did a study on data privacy where they found out that 3/4 of US people thought it was very important that they be in control of who can get information about them. So large majority. And that 9 out of 10 feel they have lost that control. And then finally, there's a Sage survey study that indicates that 84% of companies don't understand what GDPR means, and only 74% are confident they will comply. So the narrative is that trust is vital to our future and innovating in the digital economy, that users think it's essential they control their data, and they've lost that, and companies aren't doing enough about it. So I think this is certainly a turning point where that's going to need to change, and it becomes a competitive advantage to be able to treat data privacy with respect to meet these users over your competitors. So if that's the backdrop of data privacy, we want to go into detail about GDPR as a great example for well thought out data privacy best practices that also would allow you to comply with that specific regulation. What we've done is distilled down that 261 pages into 5 key concepts that we'll walk through. It kind of gives you your elevator pitch to say, what does GDPR mean to me when you're talking to other people, to have a handle quickly to explain how it affects your organization. It starts with consent, and when you ask for information, what do you get by way of agreement from users? It goes on to the rights the users have now that you are borrowing their data that they have while it's in your possession. It leads to an audit trail or a way for you to prove and log that you're taking and adhering to the consent and data rights. And then it also, GDPR talks about a process and approach that allows you to build systems that are inherently respectant of data privacy. And then finally talks about how you communicate when there is a breach of the data with which you hold. So let's start by talking about consent. And for each one of these, we'll show a quick snippet of the regulation that's easily readable and then talk about what it means and look at specific examples in the wild that adhere or not. So consent starts on recital 58 of the regulation, talking about the principle of transparency necessitating on enterprises that any information that you share with them, it needs to be concise, very accessible, very easy to understand in clear and plain language, that always be used. And it goes on to say that personal data cannot be kept longer than necessary, that there's a time frame this. So what does that mean? What does being transparent and being explicit mean? It means when you are asking for a user's information, you need to tell them what you're capturing, specifically for what purpose. So not saying for generic marketing purposes, but for the ability to communicate to you about a webinar you're signing up for would be one specific example. And for how long? If you don't have a need to retain that information for that purpose indefinitely, you need to specify a time frame thereof. And the no legalese can be a hard one, but the regulation even talks about something that a child would be able to understand. So it can't be buried in fine print. And explicitly, we already have a fair amount of legal language which inherently hides the ability to give consent because they're acknowledging that people won't read that. So it needs to be separate thereof. A couple other specific use cases that are literally in the regulation about the way that you get this consent. In particular, a silent action or a pre-ticked checkbox on a form or any activity thereof is not consent. You need a physical action. And also that when you're processing for multiple purposes, the user's consent needs to be explicitly given for each one, and that they need to be able to withdraw this consent. So active opt-in, if you don't have a checkbox at all, that's not taking any action, right? So just submitting the form. And you can't pre-select that checkbox that you've chosen to give consent that they haven't. And then you can't have blanket consent, right? You need to get the use case that you're going to communicate with them for the purpose in each instance. And you need a way for them to be able to revoke that that's easy to access. So that think of the unsubscribe that you would have on an email, but for all use cases of which you garnered that information. Here's an example for SuperOffice CRM where they had a form before, very similar to many of the forms that we have exist today, and then how they become GDPR compliant. You'll notice that there is legal language at the bottom of the first one. Everyone ignores that. That's what the regulation acknowledges and says we need to break that into an action to click the checkbox. And there are two. One is to say that I agree to your policies and your terms. And the second is I'm giving this information to you for you to send me something, and I have a marketing purpose beyond that, which is I want to keep you updated and add you to my contact list. So we're asking for that separately and not requiring that to get that free trial. Another example by Sainsbury's where they've done a really good job explaining in clear language and requiring the action. And in this case, when you're doing contact permissions, you're saying, yes, I'd like to hear about more, or no. It's truly a polar click before you can even click register. I think there's some gray area here when you look at contact permission about what they're asking for. It's a pretty wide purpose. It becomes almost whatever marketing purposes we want to have for an indefinite time period across any channel. So I think you could say that there's some gray area there about the regulations acceptance of that. And then after you have consent about the user's data, there's a new set of data rights that apply, which Bob will talk about.
Thanks, Ryan. This is Bob Beach. As Ryan mentioned, the regulation introduces a number of rights that essentially give users control over their data. So again, this idea of users taking back control of their data. So the first question is, well, what is that data? What constitutes personal data? And the regulation isn't very explicit here. It doesn't lay out a set of specific fields that would be considered personal data. Instead, it's pretty broad, and what it essentially says is that any information that can either directly or indirectly identify an individual is considered personal data. The direct identifiers are pretty obvious. Things like a name, an email address, a government-issued ID, an application or system ID. Those things, if you have them, you can easily identify an individual usually. The indirect identifiers are equally important and maybe require a bit more thought. So a real good example, and one that has come up most recently, is the computer IP address. So anytime someone is using a device, a mobile phone, laptop, PC, whatever, when you connect to the internet, you're essentially given a unique IP address, and oftentimes that IP address will be dynamic, meaning that it's different every time you use it. You use your phone today, you get one IP address, you use it tomorrow, you get a different one. On its own, that IP address, that dynamic IP address, cannot uniquely identify an individual. However, with some additional information from, say, an internet service provider or from an IT department, if you're able to take that information together, you would be able to identify an individual, and therefore, IP address is considered personal data. So you need to be very careful when you're looking at the data that you have and that you control, because you might have some pieces of information that on their own, aren't able to identify an individual. But if you can easily, or it's reasonable that you can marry that data with something else to identify an individual, then it would be considered personal data. So we have this personal data, and the GDPR has again, it's introduced a number of rights around that personal data. The first one, from which all of them stem from, and I think what you'll see as we go through the rights, and we won't go through all of them, we're just going to cover a few of the most relevant. The first one is the right to be informed, which essentially just says all users have the right to know what information you're capturing about them and how you're using it. Now, from that right comes the second right, which is the right to access. And what that essentially says is that users or data subjects, as the GDPR refers to them, have the right to access, to see the information that you're capturing about them, and have the right to make requests regarding that information, regarding that personal data. So the question is, well, what are types of requests that could be made around that personal data? Well, certainly someone could request updates or changes, and that's the right to rectification. And that essentially says that, hey, if I see my information and there's something wrong with it, it's incomplete, I have the right to request that you change it and correct it. Users also have the right to have their information deleted. This is the right to erasure, or the right to be forgotten, as it's referred to. And again, that's fairly obvious, but users have the right to say, I want you to delete everything that you have about me. The GDPR, and we'll talk about this, I think, several times, but the GDPR doesn't explicitly tell you how to technically implement the handling of these requests. However, you do have to have a pretty strict process around it. And the first step in that process is you have to be able to verify the identity of the requester. You have to be sure that they're who they say they are. The second thing is that you have to be able to track the requests. We're going to talk about auditing in a minute, but you have to be able to track that the request came in and how it was handled, and that you completed the request within 30 days, and that's a stipulation that is also in the regulation. And of course, you've got data about these users in many different systems, but maybe just taking a quick step back, let's talk about what we mean by users, or data subjects, again, as the GDPR refers to them. For the context of this webinar, we're generally talking about those users, those people that you're marketing to, users that are in your CRM system. But keep in mind that data subjects or users and personal data would also come from employees of the firm. So if you've got professional data that is in your CMS that you're using for marketing purpose on your website, for recruiting, you might have prospective employees that are submitting their CVs that are providing you with personal data as part of their job applications and so forth. So it's broader than simply who you're marketing to. In any event, you have this data in a variety of systems: CRM, marketing automation, content management systems, even third parties that you work with have this personal data. And you have to be aware of that, because when someone makes a request to delete or change their personal data, you have to do that in all of the systems where that data resides. And you do have a responsibility to do that with regards to third parties. And there's always the question about, well, why do I have to worry about third parties? You really need to think about this again from the user's perspective. They're sharing information with you, their personal data. They don't know all of the third parties that you may be in turn sharing that information with in performing whatever business activity you're performing. Think of running an event. You may capture registration information, but you may be working with a third-party event management company whom you need to share that information with. At some point down the road, one of those attendees might come back to you and say, stop sending me marketing materials. In fact, I want you to delete all my information. It's your responsibility not only to delete the information that you have, but also to pass that request on to any third parties, in this case, that event management company that you've worked with, to ensure that the data is rectified or deleted there as well. These rights are not absolute. There are certainly situations where you aren't obligated to comply with the request. If there's a legal basis for keeping the information, or if it's in the public's best interest to keep the information, you can do so. So something to keep in mind. This is a very simple example. Obviously, it's a web form, and it's kind of the final step in the process of a user wanting to have their information, their account deleted. You can imagine that leading up to this, they logged into some system somewhere, there was an option to delete their account, and now they're here where they're going to provide some information as to why they want to delete their account, and then they're going to confirm the deletion. The real interesting point about this that I want to highlight is the confirmation is by re-entering their password. And the reason why that's very valuable is that's another way to validate and confirm the identity of that user. Again, you have to be sure that any of these users that are making requests to change or delete their data, you have to make sure that they're who they say they are. And this is one example of how you might do that. The next data right that I'm going to talk about very briefly is called the right to portability. And what this right says is simply that a user has the right to ask you for and for you to provide them with the personal data that you have on them in a structured, commonly used, machine-readable format, so that they can take that data and easily share it with someone else. A real simple example, I'm not sure if it's a great example, because in this example you might have employment agreement that prevents you from doing this. But imagine as a law firm, you have data about your professionals, and one of those lawyers leaves the firm, and they ask you for an export of all of their biodata because they want to take it to their new firm and easily import it into the CMS to get on the website of the new firm. Again, maybe not a great example in terms of does this really happen, but that is an example of what portability means. Being able to take that data that you have about a user, export it in some standard format so that they can take it and bring it somewhere else. The thing that isn't outlined specifically in the regulation is what that standardized format is. Again, that's to accommodate changes in technology, changes in information, and so forth that may be happening down the road. So those are the data rights. I mentioned, and Ryan alluded to earlier, about this concept of auditing and having an audit trail of all this information. I really think this is a kind of foundational part to both the consent piece that Ryan talked about and the user data rights. And what the regulation is requiring is that you have to be able to demonstrate that a user has given you consent, and you also have to be able to demonstrate or prove that you've responded to requests appropriately and within the given time frames. And so what does that mean? And that means that in some systematic way, you have to capture things like who made the request, what was that request to change personal data, when was the request received, who handled it, when was it completed, how long did it take. On the consent side, it's being able to show that someone gave explicit consent or that they withdrew consent. You have to capture this information in the event that you need to prove to the Commission that you are compliant with the regulation. This last example, I think, is actually a great example of everything we've talked about so far. I suppose we could have shown a SQL database table that had audit information in it, but this, I think, is a little better visual. And what this is essentially is a user self-service portal where they can manage, where a user can manage their information and their consent. And so if you look at this, clearly there's a place that shows me the information, my information. That's that right to access. It gives me the ability to change it. That's the right to rectification. I believe, actually, if we were able to scroll down on this pasted screenshot, there is an option to delete the account, which would be the right to erasure. Up in the top right, you see there's a button to download my data. That's the right to portability. And throughout this form, there are consent options. So this is sort of a place where a user can come and manage all of that. And you can imagine behind this having some auditing system that keeps track of when the changes were made, what the changes were, and what the purpose was. And so that's an example of sort of a front end to building an audit trail of personal data changes and granting or withdrawing consent. So I'm going to hand it back over to Ryan. Ryan's going to talk about things you need to think about proactively as you start planning new initiatives, new websites, new applications, and so forth.
Yeah, it's a smart approach by the regulators to be aware that they can't just give you a bunch of checkboxes to follow and you will have great data privacy and security. That there actually is a way of thinking that they need organizations to take to do this, achieve their goal, which is to reshape the way they treat data privacy. So we'll go to Article 25, which talks about data protection by design and default. And it stipulates in particular that a controller, that's you or the enterprise that is borrowing the data, should be obliged to implement appropriate and effective measures and to be able to demonstrate compliance of processing activities, including the effectiveness thereof. So there are numerous ways to do that. One of the ways that's emerging as a good fit for this is a formalized approach to building systems called privacy by design that forces privacy to be baked into the building of applications. And these founding principles, regardless of GDPR, are really good principles to keep in mind to make privacy important. It starts by being proactive, not reactive, right, preventative. And why this is so important when it comes to data privacy is that once you have lost the personal information, there's no way to put it back in the box. Once it's out in the wild, you cannot properly give recourse to make it as if it never happened. So it's so essential that that first step never occur. Privacy as the default setting talks about not making people take additional steps and options to be private. Sort of if Facebook took this step, which is like, no, we won't assume that it's okay that we share your information with others through third parties you're connected to. They would have been protected from this. Privacy embedded into the design in every step. So I think of this like responsive design and accessibility and SEO in the applications that we build, that all of the elements and little micro decisions you make, it doesn't have to be hard work. It's just a subtle twist of mindset where you can include this without actually incurring additional costs to do great data privacy. And this is really important too. They're talking about full functionality where it's a positive sum. It doesn't mean data privacy only. It means you achieve your business goals and your enterprise objectives and your marketing efforts, but you do it in a way that's respectful of data privacy. End-to-end security. Security is about having a comprehensive approach, not just turning on SSL or buying an expensive security tool, but it's about process and approach and training and technology, and thinking about the data, its full life cycle, every step that it transposes across your application, and every risk vector, and making sure that there's some protection there. And the last two I really combine when I think about visibility and transparency and thinking about being user-centric. If you think about what a user wants, given that their psyche and the backdrop of the breaches that they're aware of, you need to be transparent to gain their trust, to get the marketing information that you need to be the fuel for your marketing engine. But you can still achieve that. And the final one has to do with the communication strategies and requirements that you have when and if any data is lost that you have borrowed and loaned from your users. This communication from the enterprise to the data subject, so that's to the people whose data you lost, needs to be communicated to them without undue delay. And then separately, as the controller, as you become aware of a data breach, you have not later than 72 hours where feasible to notify the supervisory authority. So the time frames are the key here about what you have to do, and the fact that you need to communicate it. So there's transparency in this too. A key part of being able to communicate about a data breach is being aware that it exists. So what are the protocols, what are the tools that you have to do audits and operational controls to be aware that the data under your control has gotten out of that control? And then being able to handle the time frames requires that you pre-think this. It becomes fire drills that you need to be doing on a regular basis, and it certainly becomes that agreement by many different parties in advance. With all of the necessary parties involved, you can't get them together after the crisis. You're going to have a plan in advance. And this does go to the C-level, right? With these data breaches, C-levels don't have their jobs after they handle them incorrectly. And part of the way to define the right way to do things is look how not to do it. And we've got a lot of examples like those where it's about delay and not sharing the fullness of the information. GDPR changes that. So we have the 5 key concepts that I think we can all wrap our heads around and think about, sort of more concrete impacts to our applications, but we wanted to take it a step further and talk about a particular applied example for marketing automation, and to show that modern marketing doesn't have to stop with respect to data privacy. It just has to, you have to turn your idea on at about 90 degrees and you can still achieve that. So this is the modern digital marketing ecosystem, right? We've got a website with a content management system that users are engaging with. And you've got an email or a marketing automation tool, and we all have sort of different ecosystems, but something that fills that spot that allows us to have a different channel of communication there. And then likely a CRM system that's going to have some offline information from interactions offline for our users. And then we ideally have interactions between those systems, and you've got different personal information and facts about users that you can use to combine to create compelling experiences for them, right? Personalization and drip campaigns and otherwise. And then ideally analytics that's showing you what's working and what's not. So let's look at a scenario that leverages an ecosystem like this. So you're starting with a simple marketing activity, a campaign to have people sign up for a webinar that shows your thought leadership. So what changes in that world now? It's a lot like, it's exactly like what you're doing now, but it's about getting that consent in a different way. So we need to have an active opt-in, a checkbox, or some action that a user takes to say, yes, I am okay that you communicate and store information about me for a specific purpose. And that purpose would be the ability to communicate about an event, such as a webinar, on a given date. But it does have this time frame to it. So if we're taking it to the letter of the regulation, we wouldn't need the information after that date. But then we're doing more advanced things. So webinars are really great marketing tools because they're fairly specific. So those who attend them, you actually know quite a bit about them, which would allow you to have targeted thought leadership from that after that event, from that contact list, as a follow-up to that. But in the world of respectful data privacy and GDPR compliance, if we were to communicate a quarterly newsletter to that same contact list with which we garnered from all the webinar signups, given what we said we thought about before, we need to get consent again to be able to do that. Or if we thought about privacy by design and we thought a few steps ahead, we could have asked for this on that first webinar, right? On that first sign up, we could have said, okay, this is, our privacy, our terms and conditions you're going to agree to, and you're going to agree for communication about the webinar, and then we also have a newsletter you can sign up for, and that would be a separate thing with which you would be able to actively opt in for that user. Will that have some reduction had you not asked that question? Yes. Will the people that do opt into this be more likely to be receptive and useful of that knowledge? Yes, one would assume. Then we go a little bit further into marketing automation. We have that user clicks on the newsletter on links that feed back to the website. That gives us an opportunity, again, with knowing the email that they're from, maybe tie that to the CRM system, the fact that they went to the webinar. We can use those facts in modern marketing to be able to show hero areas and highlights and surface our experts in that area they're interested to and present a good picture of our organization in that light. In the world of respectful data privacy, you need to be transparent about that. You need to indicate if when they click on that, you're pulling from a CRM system that they're an existing client or customer. If that information pre-existed in the CRM before you got consent about it, you need to be able to get that consent. So I think this will likely form something like what happened in the cookie policy. So when you come to that site, if we're using personal information for which we didn't otherwise get consent to do personalization efforts, you need to ask for it, right? And so that means that first visit's not going to be able to do it. But if you propose the case for why you're doing it and they agree to it, can continue on. And there are two types, implicit and explicit personalization. That explicit is we have a fact that we know to be true about you that we gleaned in some way. And that's what we're talking about here. If it's implicit personalization, which is just that as you peruse a site, we're able to, use machine learning to understand people like you clicked on these 3 pages, you're likely to like this 4th one. That isn't necessarily personal identifiable information. We might be storing a cookie we still need to get clearance from, but it's just subtle differences from what's already happening now. And then maybe a user that's been on this journey decides they would like to make an erasure request. So it goes back to what Bob was talking about. They do need to prove their identity in some way. So if you think about the prior 3 steps, and if that was a system with which they engaged with, and they did, right? There's email and there's sign up. If we use those tools and where that information was stored, it's much more likely and easy to prove identity. And we do need some system. This can be manual. Technology helps with things like this, which is workflows around acknowledging that the request has been made and adhering to that 30-day time frame. Got to think about how you're going to remove it from all the systems. Again, it could be manual, but you need some kind of process that doesn't just remove it from the one email system that they clicked, forget me, or take away consent, but it actually goes to the others, because it would be a breach if they say, forget me altogether, and then you do another follow-up because that system was not updated. This also gives us a chance to talk about specific examples for which that right to erasure is excluded within the regulation. The server logs, or when you visit a website, that website is storing every visit and the IP that went to it. That is often needed if there is forensics around a hack or something like that on a site. So there could be a legal case to be made that server logs and the IP that identifies the user is something that cannot be expunged, that you need that as an organization to have that right. And certainly if you're integrated with CRM or with an existing client, they're not asking you to remove financial records that you would need for the audit that certainly contains addresses and names and those kind of things. You need to protect that like you always have, but not have to remove it on that kind of request. So Bob's going to talk about a process and approach that you can take now to update.
Yeah, and I'm just going to add on to Ryan's last point about examples where the right to erasure doesn't apply. Another one would be, we're talking about GDPR requiring that you're auditing when people make requests, and part of that audit is who made the request and when they made it. So clearly you are retaining some of that personal data, but it's, you know, something that is driven by the regulation. So lots of things to keep in mind there. So as Ryan said, you know, we started at a pretty high level with what GDPR is, and, you know, gave some statistics that hopefully, you know, helped to support the urgency and importance around data privacy. We took it down a level, got to, you know, a greater deal of focus around what is applicable to all of you as marketers. And now we want to talk about what are some things that you can do right now. All of you have systems today that you need to ensure that are meeting the regulation, that are compliant. Now, many of your organizations may have broader GDPR initiatives underway already, and if so, you should align with them for sure. Others you may not, and in those cases, perhaps, you know, the marketing organization can kind of take the lead around driving this idea of data privacy and GDPR compliance within the firm. In either case, the place that you need to start is to understand where, from a marketing perspective, you might be at GDPR compliance risk. And if you do any research on how you start identifying risk, usually you see something about, well, you start by data mapping. And that's not wrong. We just think that that's difficult to do. These systems, as you all know, are so complex now that it's unlikely that one individual or a couple of individuals know all the data and can start effectively mapping it. What we do with our clients on these initiatives is we start with a visual system diagram, which essentially lays out all the components that are involved from a marketing perspective. We have a website context, so we come from the website first. We work outwards. We identify all internal and external systems and applications, any data that they hold, any plugins that are being used, any links to other websites, web analytics that are being used, any integrations with other systems, what those data flows are, so forth and so on. Even looking at what are your supporting environments. You can't forget that you have QA environments and test environments and development environments that likely have some user personal data in them. Disaster recovery sites, even backups and archives will have, obviously have personal data stored in those things. And it's not that you necessarily have to do anything with those, it's just at this point you're trying to gain an inventory. And furthermore, you know, again, we sort of come at it from a web perspective, going through the website page by page, so that you can find any and every form that's being used, any legal notices, privacy statements, cookie warnings, URLs, you know, sites you might be linking out to, mini sites that, you know, you're heading out to, external sites that you might be embedding into pages on your site. Going through the content management system. Again, you're trying to build this inventory, and the purpose of this is that you can start identifying, we call them areas of interest. They're not necessarily issues with compliance, but they might be, and they're areas that you need to dig in further. So you come out of this armed with the complete inventory of, you know, the complete system, as well as identifying some things that you need to look at a little bit deeper. From there, you need to understand what the real risk is with any of these areas of interest. In order to do that, and to do that properly, you need to involve your GC, your data privacy, your data protection officer, or someone that can legally interpret the regulation. I think we've said a number of times on this webinar that the GDPR regulation, it's broad in many cases and open to interpretation. And each of your firms might interpret different parts of the regulation differently based on the information, the personal data that you're capturing, the processing activities that you're going through. And so having identified those risk areas, you can have your GC or someone, you know, representing the legal side assess that risk and to make a determination around what your risk appetite is. I mean, we've worked with clients and we've laid out recommendations, and you know, the GC will come back and say that's a really good recommendation. We just don't think that's a very big risk for us. We're not going to do anything there. In other cases, it's the opposite. We lay out a recommendation and the GC will say, that's a really good recommendation and we're really worried about that area. We want to do more there to make sure that we're in compliance. In any event, once you've identified those areas and you've sort of had legal counsel look at those and assess the risk, at that point, you know the areas that you need to work on to mitigate that risk. The last thing I'll talk about in terms of the process is to not forget about the user experience. Everyone's got loads of projects on their plates, and the GDPR deadline is 63 days and 7 hours, actually almost 6 hours from now. It's coming up quick. There's lots of things going on. It's real easy to have the attitude of, let's just do the minimal required to be compliant. And that's okay. Again, the regulation doesn't require or stipulate a specific type of implementation. But for lots of reasons, we do encourage you to think through the user experience. And I'll just give one example here. If someone wants to make a request to access their data or change their data or have their data deleted, one way you can handle that is certainly just on your website, say download this form, fill it out, put it in an envelope, get that form notarized, include something that identifies you, your Social Security card, a photocopy of your passport or something, mail it to us. We will review it, and within 30 days we'll get back to you with what our response is, whether we've handled the request, whether we need more information, and we'll continue back and forth until we've satisfied your request. You could certainly do that. That's not a great user experience. And so just think through the forms that you're presenting on where you're asking for consent. Keep them simple. Keep them consistent. As Ryan had mentioned, the privacy policy, it needs to be very clear and relevant and prominent. And think through how you want to interact with users when they do have requests around their personal data. Lastly, this is sort of the salesy part of the webinar. And all I'll say is we are doing this with clients today. We're helping them sort of kind of go through the system diagramming purpose. If this is something that you're interested in, please reach out to your account managers. We're happy to talk to you more about what we're doing and how we could help. So just let us know.
So we've shared, hopefully, a high-level understanding of GDPR and the underlying landscape of data privacy, given 5 key concepts that are hopefully easy to latch onto and give you a summary of what this means to share in your organization, and then a process that you can take to start acting. So I think we'll leave it that I think GDPR and respectful data privacy don't have to be barriers, burdensome hurdles to take, but just a new way to think for modern digital marketing that can feed into great marketing for you and an opportunity. With that, we will see if we have questions from the attendees.
Thank you, Ryan and Bob. That was very interesting. To everyone listening in, just as a reminder, if you do have a question, you can submit it through our chat function located at either your lower right-hand corner of your screen or within the blue drop-down bar. I know I said green before, but it is blue, at the top of your screen. Also, as a quick note, we will be sending slides and recordings the next couple business days. And we do have quite a few questions. We probably won't get to all of them. But with that, we're going to take a quick second to look over, and then we'll be back in a minute. Thank you. Everyone, all right, so our first question, cookie consent banners are becoming more prevalent upon visits to websites. Do you believe the consent needs to be given before allowing site visitors to navigate the site, or do you believe by navigating the website, implied consent is given and adequate for GDPR compliance?
Yeah, so that's an interesting question. It's not really specifically addressed as part of GDPR. There's actually another regulation called e-privacy, or the e-privacy directive, that is essentially known as the cookie law, and that's also being changed. If I got this correct, the intent by the Commission was that e-privacy regulation would be updated and ratified and ready to go by kind of aligned with the GDPR effective date of May 25th. As of now, it hasn't been. What they're expecting, and I think the thing that they're hung up on is exactly this question of if you have to ask for consent before you drop a cookie onto anyone's machine. So the question hasn't really been answered. It seems to be leaning towards that is likely to happen, that the regulation is going to stipulate before any cookies are dropped, you have to ask for consent for them, but it hasn't been finalized at this point. So I think most of the time, if you view EU sites, a lot of them will just say, hey, by browsing this site, you're giving consent. For the moment, I think that's okay, but eventually, and maybe shortly, that could be changing.
Thank you. So a second question, Ryan, you showed a kind of before and after form of what compliance could look like. Are companies doing this for all of their forms or just on their EU relevant sites?
I think you're seeing examples of both. I would caution if the determination is made that it doesn't apply to EU, that you think fully through whether an EU user, the use might change, right? You could have a form where over time it changes for the audience with which you drive it there. When you think about different reasons to have landing pages to drive to forms. And then just leave the question separate from regulation, which is what is a good experience? If we're doing it just to abide by regulation, you could say maybe not. But if you're doing it because regulation asks us to create a better user experience, which is more likely to have people give us information because they trust us more, it's worthwhile to do it on all.
Great. So the third question, when you say we need to get consent for each use, are you saying that we cannot send a general consent form asking if they wish to receive communication from us? We need to send one for each event invitation, for example.
Yeah, certainly you could ask for consent for multiple events in a given topic. That would be clearly okay, not every single event. It could almost be like spam to ask to get consent to do all that. But then it gets into the gray area of generic marketing purposes as we see fit would be the one extreme. Asking for consent to communicate about each event is the other, and then there's a gray area in the middle with which we each need to find the right balance.
A good example would be, for a law firm, a user might give you consent to send them information about your IP practice. You can't then start sending them information about another practice without their consent. That's the essential letter of the regulation.
All right, so another question, are items like Google Analytics and marketing automation tools considered third-party vendors?
They are, because they're separate entities which have personal information with which you don't control the servers, the hosting thereof. And so certainly all of the big players in that space have been working on their own GDPR compliance. It's a slightly different version of it within the GDPR language. We didn't share this before, but there's a notion of sub-processors. So third parties are, enterprises, the controllers, that's you. If you use a third party, they're considered a sub-processor of that information, and there are requirements that you have that's carried over to them. And so each one of those sites, as part of the GDPR compliance process, is to go to them and vet that third party that they are adhering to their side of the equation. You are responsible for using them if they're part of the breach, and that's why it's essential to check on that.
All right, so last question for today. How strict is the May 25th deadline?
So we have been in a grace period for the last 2 years. This regulation has existed on the books as a law as of 2016. This date of May 25th is the point at which they will start regulating it. And we did some research before this to see if there was any wind blowing that they might push it out like they sometimes do in regulations. And there's zero insight to that. And I would almost say that the news cycle and the news flow this week with the Facebook breach is certainly not going to give a politician a way to say, how about we delay this a little bit more.
All right. Well, thank you, guys. Thank you to everyone who has joined. If we didn't get to your question, we will follow up. As another reminder, we will send the slides in the recording. So if you think of any other questions in the meantime, feel free to reach out directly. And thanks for everyone for joining. Have a great rest of your week.
Thanks, everyone.
Thank you all.